I don't want to slander SEAL Team 6 because they're, no,
What's
seriously,
up,
they're
everybody?
honorable,
We're finding out if,
they're honorable
Donald Trump is above
officers,
the law.
and they are bound by the Uniform Code of Military
Trinidad?
Justice not to obey unlawful orders.
Check, check.
No,
All right,
I think one could say that it's not plausible that that is legal, that that action would be legal. And I'm sure I've thought of lots of hypotheticals. I'm sure you've thought of lots of hypotheticals where a president could say, I'm using an official power, and yet the president uses it in an absolutely outrageous manner.
What do you guys think?
That, if we're an objective determination, may well be an interesting approach to take.
So apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face,
I mean, if he gets in, he could just
is that plausible
himself,
that would be within his right to do?
Hey guys,
Absolutely,
you guys
Your
think
Honor.
that
We have the historical precedent reciting the lower courts of President Grant sending
civilian?
federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment, or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to address a more higher level point, a fundamental point, which is that, as Justice Alito's question indicated, there's a whole series of structural checks other than criminal prosecution that are designed to deter these kind of, outlandish scenarios or extraordinarily obviously illegal things. And that's been viewed in this court's opinions going all the way back to at least Martin against Mott.
Where do you think the D.C. Circuit went wrong in how it determined what was official versus what's personal?
Well, I read the opinion below in this particular case as adopting a categorical view. It does not matter is the logic of their opinion because there is no immunity for official acts, and therefore,
at his house in a bathroom,
that's the end of the story. I don't really think they went wrong in Lasingame in the civil context when they engaged in the same determination with respect to what's official and what isn't official. There, we agree with most of what that opinion says.
And for some official acts that are not within the Article 2 exclusive power.
Chocolates?
Okay, so official acts, but not within the Article 2 exclusive power. Even for those, I assume you would think that a clear statement has to be required, a clear statement in the statute covering the president if the president's official acts are going to be criminalized.
Absolutely. Obviously, the issue is, at the highest possible level when it comes to the unrestrictable powers, like as in this indictment, the
Well, I'm assuming the exclusive powers are walled off and can't be prosecuted before there's a lot of official powers that are not exclusive to the president under his Article 2 authority. But for those, I understood you to be saying at a minimum there would need to be a clear statement in the statute referencing the president so that the president's on notice.
You were completely correct, Charles. Neither one of these presidents had the right to have these classified documents.
That's absolutely correct, and that'd be consistent both with Franklin and Public Citizen and cases along a series of other clear statements.
That's why I don't like either one of them.
Go ahead. Go ahead. So you concede that private acts don't get immunity?
We do.
Okay. So
the thing is that President Trump is being brought in front of, or his case is being brought in front of the Supreme Court for having all these classified documents at his house. Now, it's not just Trump. It's also Biden. Biden had a bunch of classified documents at their house. They both did terribly illegal things. Only Trump right now is on trial. Biden's not on trial. Biden is not on trial. And he's had that stuff over at his house since he was vice president. Biden's not on trial, which is a terrible, what is that called? It's a double standard. But the thing is, this is also a double standard. Should presidents have more law than the common citizen? Should they be above the law? That's what's being held here. And people are saying that since he was president, he's got immunity. So we'll find out if that's true or not.
and petitioner and a co-conspirator attorney directed that effort.
They should both be on
You
trial.
read it quickly. I believe that's
Yeah.
private. I don't want to.
So those acts you would not dispute.
one
Those
hide
were private,
documents and the other
and you
one turned
wouldn't
them in?
raise a claim that they were official.
As characterized, what we would say, Your Honor, if I may.
Hey, Chris, they both held documents. We didn't even know Biden had documents up until a couple of years ago, and that's because they were found there. So, yeah. Also, 15 and 20 boxes compared to 15 and 20 documents compared to 15 and 20 boxes. Listen, Chris, I know you're trying to say that one illegal is not as bad as another illegal, but that doesn't work. They're both doing terribly illegal stuff. And by the way, I don't bow down to Biden as my God like some of you might. I only have one God, that is Jesus. I don't care about your human gods that want to screw you over. Look how they handled it. Yeah, by not taking him to court. Very interesting. It's very interesting. Anyway, let's continue.
What we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the
Biden did it in ignorance. Oh my gosh. Guys, listen, I understand that you guys bow down to that man as a god. People bow down to Trump as a god too. But when humans screw up, if I screw up, if I had one single, even out of ignorance, illegal document, secret document, I would be sent to federal jail. And yet our presidents aren't. Do you see the problem here? No, you don't, because you bow down to Biden and Trump as your gods.
the American public, communicating with Congress about matters of enormous
Thank you.
concern.
Thank you.
Thank you, counsel. And
I don't believe it would be able to go forward. I mean, there could be a case where it could.
Yeah,
But
bowing
if you
down,
look at even the
sucking all
government's
over
brief in
his
this
toes,
case
Chris.
divides up the indictment into things that, other than the electors'
I don't even vote. I do
don't
vote.
really.
I'm not voting for those two, but I
they
do
haven't
vote.
disputed that they are official acts. But what they do is say, well, we tie it all together
Don't even
by
vote.
characterizing
I
it as
voted
done
in
and using
every
the
presidential
allegations
election,
that the
every
court just
single
referred
one.
to by an improper private aim or private end.
Hey,
Again, that's
you're
their
stating
words, and that
facts
just
by
runs
sucking on toes,
loggerheads,
Chris.
you know, dead set against this court's case law
Vice
saying you
President
don't
cannot
look
have
at
any
when immunity
classified
determinations,
documents. The president can't declassify.
the motive,
Well,
improper
there you go.
motivation or purpose.
thank you. Justice
They're both
Thomas?
trash human beings.
Mr. Sally,
Who
in
did you vote for?
assessing the
As my American right, I'm not going to
official
tell you
acts
anything.
of a
Why
president,
don't
do
you
you
guess?
differentiate between the
That Kennedy guy was
president
an Epstein
acting
Island?
as president
I ain't voting
and
for him.
president acting as
Who is
candidate?
JFK Jr.?
Yes, we do, and
Who is
we
this?
don't dispute essentially
Sorry, I
the
misunderstood
blazing
something
game
you said
discussion of
yesterday
that.
then.
Okay,
But of
now-
course, that has to be done by objective
That
determinations, not by
sounds like
looking
a
at what was the
lot
purpose
of
what you did.
misunderstanding going on,
That's the most
Shelby, but
important
thank you
point
so
there.
much for
Did you,
apologizing. A lot of these people in
in
here
this
won't apologize because they
litigation
bow down to
challenge
their
the
gods,
appointment of special
which
counsel?
are Biden
Not directly.
and
We
Trump.
have done
That
so
is their
in the
gods.
Southern District of
Human
Florida
gods, by
case,
the
and
way.
we totally
Human
agree
gods.
with the analysis provided by Attorney General Meese and Attorney General Mukasey. And it points to a very important issue here, because one of their arguments is, of course, that we should have this presumption of regularity. That runs into the reality that we have here an
Jesus is the only true
extraordinary
God. Facts, Pedro,
prosecutorial power
facts.
being exercised by someone who was never
People are
nominated
told
by
what
the
to believe
president
right now to the
or
talking points.
confirmed by the
Unfortunately, they
Senate
usually comply.
at any
Facts.
time. So
Facts.
we agree with
Trump
that position.
2024. There you
We
go.
hadn't raised it yet
There
in
you
this
go.
case when this case went up on appeal.
Biden 2024.
Justice
There you go.
Alito?
It doesn't.
When you say that
That
the
doesn't
official
bother me.
act
What
should
bothers
be
me
expunged
is when
from
people exploit
the
the
indictment, that
system.
in itself would not achieve very much unless
We are held at a completely
evidence of
different
those
standard
official
than,
acts were
than these
precluded at
people.
trial. So is that what you're saying, that the
believe in
prosecution
no
should
gods.
not be permitted
Well,
at
depending on
trial
who
to
you vote
prove the
for.
official acts as part of the conspiracies that are alleged?
Absolutely, and we think that's just the clear implications of Brewster
Exactly.
and Johnson in their
Facts,
discussion
Daphne.
that's in a very analogous context.
Thank you.
Justice Sotomayor?
I'm a little bit confused by that.
What are you
If
confused
you
by?
have a scheme to defraud or a scheme to accept bribery, there's evidence from which you can infer that scheme, and one of it is that the appointment actually happened. It's an official act. You wouldn't expunge that as evidence. You would instruct the jury that there's no liability for the actual appointment, that the liability is for accepting the bribe. Similarly here, I don't think the
They're all bought and paid
indictment
for,
is
yep.
charging that the obstruction occurred solely because of conversations with the Justice Department. They're saying you look at all of the private acts and you look in the context of some of the public acts, and you can infer
Free TikTok, yeah,
the
facts.
intent, the private intent from them. So I'm not sure that I understand why your problems couldn't be taken care of at trial with an instruction, if we believe, if the court were to find, I'm not even sure how they could, but if it were to find that some public acts could not be the basis of criminal liability.
I think the best thing I can say to that is, and I think this ties into the Chief Justice's question about a one-legged stool, Brewster and Johnson and subsequent cases like Heltowski versus Meaner essentially say that this is a one-legged stool problem. It will be difficult for some of these prosecutions to proceed, and that is the implications of official immunity, which is dictated in the Constitution here by the executive vesting clause.
Justice Kagan?
Can I continue on in Justice Barrett's vein a little bit and ask you about some of the allegations of the indictment and whether they're official acts or not in your view? So the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his name against the Georgia governor.
I don't think we've disputed that that's official. I'm sorry, that is unofficial.
That's unofficial. Same for the defendant called the chairwoman of the Republican National Committee, asked her to gather electors in targeted states, falsely represented to her that such electors' votes would be used only if ongoing litigation in one of the states changed the results in the defendant's favor.
We have taken the position that that is official.
That's official?
Yes.
Why would that be official?
Because the organization of alternate slates of electors is based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power. So when President Trump
couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case, and based on the allegations, we think it's clear he did not, that this was done in an official capacity.
The defendant asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them.
Just to give a recap, Trump's on trial for having a bunch of, secret documents at his house, boxes and boxes worth, as was pointed out, in his bathroom, on a stage, like all over his house. And people are saying, well, since he was president, he's immune, but other people are saying it doesn't matter if he was president or not, he's not immune, because like a lot of this stuff happened after he wasn't president. People came over to his house. He talked about secret things. He showed secret documents. I mean, if you went to use a bathroom, you could just go read the secret documents. But, yeah, so do you have immunity if you're a civilian? No. But do you have an immunity when you're president? That's the question on trial right now.
Them to view what he views as their job.
Well, that's a different question. I mean, what OLC has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I'd put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty. That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I don't know why his voice sounds like that. He's just old, I guess.
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that might well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of
If
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And that is the wisdom of the framers. What they viewed as the risk that needed to be guarded against was not the notion that the president might escape, a criminal prosecution for something, sort of very, very unlikely in these unlikely scenarios. They viewed much more likely and much more destructive to the republic the risk of factional strife discussed by George Washington.
The framers did not put an immunity clause into the Constitution. They knew how to. There were immunity clauses in some state constitutions. They knew how to give legislative immunity. They didn't provide immunity to the president. And, not so surprising, they were reacting against a monarch who claimed to be above the law. Wasn't the whole point that the president was not a monarch and the president was not supposed to be above the law?
I would say two things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that's set forth in the very broad language of Marbury against Madison. And also, they did discuss and consider what would be the checks on the presidency. And they did not say, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says, we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And they're very clear on that in pages 64 to 69 of the second volume of Farrand.
Thank you.
Justice Gorsuch?
Just returning to the Chief Justice's hypothetical about the ambassador sale and bribery. Congress has a statute that specifically names the president and says he can be criminally prosecuted for bribery, presumably after he leaves office. Outside the core areas that Justice Kavanaugh was talking about, when Congress speaks clearly, couldn't a statute like that, Congress provide a statute like that would allow all manner of evidence to come in to prove the case?
I think our position is that would have to be an unofficial act, purely private conduct for that prosecution to go forward.
All right, but outside the core areas of executive power, if there is a clear statement from Congress that something is unlawful and it applies to the president, I'm struggling to see why in that case, perhaps, the evidence could come in.
Yeah, the strongest possible case, in our view, is what you've described as kind of the core executive powers, the unrestrictable powers within the meaning of SELA law. But again, the holding of, for example, Brewster and Johnson that we've relied on doesn't turn on how central it is of a legislative act. It just says if it's an official act, which here we would say applies basically the outer perimeter test of Fitzgerald against Nixon, that doesn't come in.
Just to give a recap, this is the trial for Trump having all those. This is to see if you're president, do you have immunity before and after you're president? That is the question. If so, this would also give immunity to all further presidents But President Trump, ex-President Trump, had a bunch of documents, boxes and boxes and boxes of documents at his house, in his bathroom, in his storage closet, up on a stage at his house at Mar-a-Lago. They found all these boxes and boxes and boxes. And so that's what the trial is. Does he have immunity? And does he have immunity from all the other cases? Every single one, because he was the president. Some people are saying, no, nobody's above the law. Some people are saying, since he was president, yeah, he's above the law. What do you guys think about the situation? In my comments, let's get back to it. That's just a rundown.
What would happen if...
By the way, this is the Supreme Court. They decide everything.
If presidents were...
unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that's what they're arguing right here. Wouldn't provide the security because the legality of that is something that's never been addressed.
Now, one of the checks and balances, in addition to impeachment that you've discussed, is subordinate liability. You don't contest that everybody following an unlawful order beneath the President of the United States can be immediately prosecuted, do you?
There was a lot of cases before.
I'm sorry, if the court is asking whether they
if
could
the President gives an unlawful order,
to be fair,
call in the troops, all the examples we've heard, every subordinate beneath him faces criminal prosecution, don't they?
That is what Gouverneur Morris said explicitly at the Constitutional Convention, that is, coadjutators could be prosecuted. There is an important caveat, because, of course, there would have to be a statute that would govern that for them to be prosecuted.
Oh, we've got lots of statutes. The criminal law books are replete. But, I mean, do you agree, is that one check that's available?
Absolutely. And, again, the only caveat that I was making is if that statute was doing what Marbury says you can't do, which is going after the subordinates to restrict, for example, a core executive function, the Franklin Clear Statement Rule might be triggered, and you might not be able to go after that president. So I don't think Congress can say, well, we can't go after the president directly, but we're going to criminalize the way that the president speaks to Congress under the exercise of the Recommendations Clause, and therefore we're going to put in a criminal statute that says if you provide false information to Congress in carrying out the president's recommendation powers, you can be immediately prosecuted. That would at least be a very difficult question. But the fundamental point of drawing that distinction between the president himself and his coadjutators, in the word of Gouverneur Morris of the Constitutional Convention, is an excellent distinction.
I don't know what he's gurgling.
Justice Kavanaugh?
Just follow up on the OLC opinions question. As you read them, and I think I read them, they articulate a clear statement rule as to this court's cases for covering official acts. And your point, I think, but I just want to underscore this, is that none of the statutes alleged here or cited here have a clear statement covering the president, therefore meaning that the president can't be charged for any official acts under these statutes.
That's absolutely correct. They're extended way beyond. I mean, this
now, that's separate from the question what's official versus what's personal, but for that bucket that is official, there's no clear statement, period.
That's right. And as to purely private conduct, we don't think that clear statement rule would be invoked. But as to official acts, these statutes, the ones charged in the indictment, are just way far afield from purporting to criminalize in clear terms the president's official acts.
And then just to clarify this, the president's not above the law, the president's not a king. The founders thought that. I think your point in response to that is the president is subject to prosecution for all personal acts, just like every other American for personal acts. The question is acts taken in an official capacity.
That's correct. And even those, of course, if there was an impeachment and conviction, could be prosecuted on our view. And we'd emphasize the whole series of structural checks in addition to that, which deter those and have successfully deterred presidential misfeasance for 234 years.
Then on the source of immunity, it's not explicit in the Constitution, but also executive privilege is not explicit in the Constitution, yet in United States versus Nixon, the court unanimously said that the Article II executive power in the Constitution encompassed executive privilege, and the same principle presumably would apply to executive immunity being encompassed within that executive power as historically understood.
That's absolutely correct, and there's a very telling passage in Free Enterprise Fund where this court talked about how there's a letter from James Madison to Thomas Jefferson at the time of the founding where Madison said, hey, as to the removal power, they did not expressly take this away, so the 1789 Congress understood that it was left in place. So if the original understanding of the executive vesting clause is broad enough to encompass that, it would have to be expressly taken away, which is the opposite of the presumption that they're advancing here.
And then lastly, I think you've acknowledged in response to others' questions that some of the acts in the indictment are private, and your view is that some are official. Is it your position then that that analysis of which is which should be undertaken in the first instance by the D.C. Circuit or the district court?
Most likely the district court under the logic of Anderson.
Thank you.
Justice Barrett?
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president. Keep in mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history. And what DOJ admits is the framers' intent. And so we say that that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assume the risk that of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay, and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted. That word conviction is right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has prerogative to do so.
2 or 3.
They haven't done a comprehensive review. I think it looks like all they did was text search for president in 18 U.S. Code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. Isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment could occur as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the thing, in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's example of a president who orders a coup, let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction in an impeachment proceeding if there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.
Justice Jackson?
Everybody's
so I think
in the
I
comments.
now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act? is being necessitated by that assumption. Because, of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be made.
Right, but I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question: could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera, et cetera. So
I say two things in response to that, both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
No, but let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high-profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, anybody on the street can sue him. We could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
He is required to follow the law. And what
but he's not. If there's no criminal if there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
All the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop, and what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife, which will.
No, I'm also. Let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office. It's
yeah.
right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you another question. Let me ask you another question about this clear statement line of questioning. First of all, I didn't see you argue that below. I don't know. I understand that you have that sort of in your briefs here, but did you argue before the D.C. Circuit something about a clear statement with respect to statutes?
Yes. In our separately filed motion to dismiss based on statutory grounds, we extensively argued not just this clear statement rule, but a whole panel.
Right, but that's not the question presented in this case. The question presented in this case comes out of your motion for immunity. So to bring in now an argument that you didn't raise below, it seems to me you forfeited it, no?
I believe it's fairly included within the question presented, especially because the court expanded the question presented from what either of the parties submitted.
But not to statutory interpretation. I mean, that argument goes to statutory avoidance, constitutional avoidance, statutory interpretation. You asked for immunity, which is a totally different thing.
I think they're very closely related logically. The question is does immunity exist and to what extent does it? And the argument is immunity at least exists to the extent that it raises a grave constitutional question. That triggers the clear statement rule. That's a really tight
logical totally circular. You use that argument to avoid constitutional questions. You are asking us a constitutional question here. So it doesn't even make sense to talk about clear statement in rule the way that it's come up in the context of an immunity question. But let me ask you this about it. I had one more question. So what is the argument that the President of the United States, who you say is bound by the law, is not on notice that he has to do his job consistent with the law? I mean, to the extent that the clear statement rule comes in at all, it's about the person not being on notice. So I guess I don't understand why Congress in every criminal statute would have to say, and the president is included. I thought that was the sort of background understanding that if they're enacting a generally applicable criminal statute, it applies to the president just like everyone else. So what is the clear statement that would have to be made in this context?
Under Franklin and under Public Citizen, Congress has to speak clearly before it interferes with the president's powers, and we have here an indictment that seeks to criminalize objective conduct that falls within the heartland of core executive authority.
Thank you.
Thank you, counsel. Mr. Dreeben.
Mr. Chief Justice, and may it please the court. This court has never recognized absolute criminal immunity for any public official. Petitioner, however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. I welcome the court's questions.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article 2 branch, can assert, as applied, Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions. That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions.
Yes.
Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here. It arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access.
Real quick, the Operation Mongoose was an operation by the CIA that was extensive campaign of terrorism against civilians, and it had to do with the Cuban project. So I'm just
to advice from the that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option. And then if I could say one more thing, because you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
Counsel, the Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said. But there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in the some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us. We are not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith, for political animus, without adequate evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath, the Attorney General takes an oath. So I don't want to overstate Your Honor's concern with potentially relying solely on good faith, but that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
But what concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those holdings. But what is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does, and it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents, and that's because one of the chief concerns of the framers was the risk of presidential misconduct. They labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution. This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding. The framers did not want that. They wanted a political remedy in case a president was engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are.
Giving you a recap, Trump had a bunch of, President Trump, sorry, I know he's some of your god. I call Biden, so I know he's some of your god too. He had a bunch of secret files, cases and cases of secret files at his house after the presidency. The insurrection, his presidency, all of his previous and, illegalities and all of his illegalities after he was president. Is he immune for life? Is he immune during his presidency? What can they try him on? Because he's got multiple different allegations out there. That's what they're trying to figure out. Does the president, being the president, make you immune from everything? Are you above the law? We're not, but is he? That's what this is.
Applied to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine. I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time, and during the trial, the former president may be unable to engage in other activities that the former president would want to engage in, and then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term. Congress is unlikely to crank up the machinery to do it, and if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all.
So you're arguing against the most far-reaching aspects of Mr. Sauer's argument, right?
That is correct. And let me turn then to why.
Well, what about, to unpack it a little more, do you agree that there are some aspects of Article 2 presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power, assume for the sake of argument, this question, that there's not blanket immunity for those official acts, but that to preserve the separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute, and I don't think that that's necessary in order to afford adequate protection for the president's valid Article 2 functions.
Well, you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Right.
Well, isn't...
Real quick, how many secret documents are you allowed to have at your house as a civilian? How many? None is the right question. Right answer. So how much time would you spend in federal court or federal prison if you had any of that? Just answer that. Because if you didn't do anything wrong, why do you have a bunch of secret documents at his house? Why did Trump and Biden both had secret documents at their house? Oh, I didn't know they were there. That doesn't work.
A serious constitutional question whether a presidential activities historically with a creative prosecutor who wants to go after a president.
Well,
yep, Clinton and Obama did
let
as
me
well.
try to backtrack a little bit.
That's what we're talking about historically is the risk that, and
I think I saw
going
what
forward,
Reagan did. Hold on.
the risk. So you can take all
I think
that.
the golden
I
boy
think
Reagan
that
did
the
as well.
question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the president. It does not name the president, Justice Gorsuch. Section 201 does not specifically name the president.
I would assume that's personal, so...
Well, I think that
that's what Brewster said.
Bribery statute in 607 says the president. I've got it in front of me, and so there is that.
Well,
let me just back up, though, just a second to what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
So is that a form? I mean, we can call it immunity, or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge. That
okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you concede that an official acts that Congress cannot criminalize. And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress. Because he objects to a piece of legislation that's going through.
Right, what?
And it, in fact, delays the proceedings in Congress.
Oh, okay.
Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word, euphemism you want to use for that? Or is that not core and therefore prosecutable?
Well,
without a clear statement that applies to the president.
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
A president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
pattern. I thought you said that was my question.
Yes,
and you said it fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. But there's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his Article 2.
He could have given speeches against it. He did.
Yes.
But he did something more, and it corruptly impeded and sought to influence an official proceeding.
Well, so I don't know. We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
I will assume it. Then there's a question of whether he has the state of mind necessarily to
Assume he
violate
does.
it.
Corrupt.
Okay.
Nobody knows what corrupt intent means. We've been around that tree
We will
twice
probably
already.
find out.
And maybe it means that he knows that he was doing wrong, is what the
Perhaps.
government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be up there blocking a congressman from going.
Well, let me get to the next layer then, which is that the president does have access to the attorney general to provide legal advice and regularly gets legal advice from the attorney general on the lawful scope of the president's activities. We could go down two tracks here. One is that the attorney general advises him that as an incident of his Article II authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the First Amendment analog to the president's official powers, which the court is exploring in other cases. Alternatively, the attorney general could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that, and I would advise you not to violate the criminal law.
And then he could be prosecuted.
No.
No. If he gets a negative opinion from the attorney general, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
Well, but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Dreeben, can we go back to the bribery statute? I, like you, understand that the only thing that is covered by that is the president is barred from soliciting or receiving funds in any room or building in the United States.
That is correct. And it's an extremely
official building. It's a very limited mention of the president.
And it really, I think,
so, as I understand this, there's two very limited provisions mentioning the president is included.
That's right.
There's a whole number of provisions that exclude the president, many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the fence.
Now, Justice Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think
that's a tautology you can't escape.
Justice Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly. That's the point, which is if he's not covered by the criminal law, he can't be impeached for it, for violating it. All right. Now, could we go further on this clear statement rule? The situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was analyze what powers were being given to in the lawsuit, and et cetera. We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
All right. So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept a bribe, that permits the president to do it.
So I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context-specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury, this is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
All right, could I go back to your brief and going back to what some of my colleagues have asked you? There appears to be some narrowing principles to the concept that the president is subject to all criminal laws in all situations.
Correct.
You agree that if it affects core powers, then he would not be subject to any laws that attempted to limit those core powers,
that
correct?
Is right.
You're defining core powers as those specified by Article 2.
That is essentially correct, yes.
All right. And the only words in the Constitution is that that have to do with the president-in-law is that he shall take care that the law be faithfully executed, correct?
That is right.
Hard to imagine that a president who breaks the law is faithfully executing the law, correct?
He has to execute all of the laws.
All right.
Well,
Counsel,
Mr. Dreeben, do you really, I mean, the presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, you know, if he makes a mistake, he makes a mistake, he's subject to the criminal laws just like anybody else? You don't think he's in a special, a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statutes that are issued in this case. I think they are fairly described as Malum and Say statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute the particular application of 371, conspiracy to defraud the United States, to the particular facts here, but would you not agree that that is a peculiarly open-ended statutory prohibition, in that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest?
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah, I'm not, as I said, I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties, and particularly in a case like this one. I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes, and then Congress in a extraordinary joint session certifies the vote. And the president doesn't have an official role in that proceeding. So it's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function, you can't obstruct it through deception, you can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito?
Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
how robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right? Both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
Well, I want to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been 2 who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer is one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are 2 officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah,
the Department of Justice
I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords 2 levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think Justice
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases.
Yeah,
Yes, but I think that the other
every once in a while there's an eclipse too.
Well, I think that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented that understanding. The Watergate smoking gun tape involved President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime, and you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of safeguard.
Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article 2 challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.
On the question of whether a president has the authority to pardon himself, which came up earlier in the argument, what's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the department has not addressed it further, and of course this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department, representing the United States.
Now, don't you think we need to know the answer to at least to the Justice Department's position?
Guys, what's going on here is former President Donald Trump had a bunch of secret documents at his house. There was what happened on January 6th, but every time I bring it up as an insurrection, people are like, it wasn't an insurrection. Okay, so whatever it was on January 6th, they're seeing if that president has immunity for all crimes previous and after he was president. That's what this is. And you guys can talk freely. I'm not going to censor anybody in the comments. You can talk freely. We have freedom of speech here. You're going to have freedom of speech in the comments. Just don't be sending threats to each other, okay? We're all Americans. Well, I mean, even if you're not, just be nice. And here we go.
Position.
Bedrock principle.
But my question to you is anybody above the law? Is anybody above the law? President or not? Is anybody above the law? And that's what we're arguing here. And if so, do we have kings or not? You know, just normal stuff.
What is required for the functioning of a stable democratic society, which is something that we all want? I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you.
Justice Sotomayor?
A stable democratic society needs the good faith of its public officials, correct?
Absolutely.
And that good faith assumes that they will follow the law.
Correct.
Now, putting that aside, there is no fail-safe system of government, meaning we have a judicial system that has layers and layers and layers of protection for accused defendants in the hopes that the innocent will go free. We fail routinely, but we succeed more often than not. In the vast majority of cases, the innocent do go free. Sometimes they don't, and we have some post-conviction remedies for that. But we still fail. We've executed innocent people. Having said that, Justice Alito went through step by step all of the mechanisms that could potentially fail. In the end, if it fails completely, it's because we've destroyed our democracy on our own, isn't it?
It is, Justice Sotomayor, and I also think that there are additional checks in the system. Of course, the constitutional framers designed a separated powers system in order to limit abuses. I think one of the ways in which abuses are limited is accountability under the criminal law for criminal violations. But the ultimate check is the goodwill and faith in democracy. And crimes that are alleged in this case that are the antithesis of democracy, that subvert it, undermine that.
An encouragement to believe words that have been somewhat put into suspicion here, that no man is above the law, either in his official or private acts.
I think that is an assumption of the Constitution.
Justice Kagan?
Mr. Dreeben, I want to go through your framework and make sure I understand it. So first, on the small category of things that you say have absolute protection,
yes,
that they are core executive functions.
Yes.
What are those small categories?
Pardon power.
Pardon, veto.
Veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received, a certain diploma, or hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more of a...
So that may be viewed as not really in that core set of functions, which nobody has any power but the president over.
Yes, I think that there may be some aspects, like directing troops on the field, in which the president's power is completely unreviewable.
Okay. Now, in the next category, where we've left the core set behind,
yes,
but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president.
All right, so in that poll, 32 people out of the 41 said that nobody is above the law. I'm just letting you know.
President?
To engage in legal counsel pointed out that bribery is enumerated in the impeachment clause, so it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that bribery is the kind of hybrid that illustrates the abuse of public office for private gain that we think is paradigmatic of the kinds of things that should be not held to be immune. In a bribery case, the public official cannot extract the bribe without the official power to offer as the quid or the pro. I guess the quo, actually. So it really is a crime that can only be committed by public officials who misuse their power. And it was one of the things that was most mistrusted. Many of the acts that are charged in this indictment or that would violate federal criminal law similarly involve the misuse of official power for private gain.
So if you were to say like what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And the third example that I will give you is the statute that would permit prosecution for contempt of Congress. The Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only 2 that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition, murder, would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected.
I really believe
or
that's either
does the
side
statute
lying in the truth.
across the board in such a
Both
wide
sides
range
can't
of
take the truth.
applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. They also seem not really before us in the way Justice Jackson suggested earlier. What do you do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue.
Lying in the truth. I don't trust Fox. I don't trust CNN. I don't trust MSNBC. I need a bunch of fact checks. And the only way to fact check is if they're all saying the same thing, I really think they're lying. And that's me not trusting the government. That's me not trusting media. That's me not trusting almost anything.
Issue, even though Justice Jackson is the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant.
I don't care who the
so that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel Stevens. It was a Key Tam case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. Reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that the Article 1 branch and the Article 2 branches are aligned in believing that this prosecution is an appropriate way to enforce the law. Congress, by making the law, the current executive by deciding to bring it. And since a building block of that submission is that Congress actually did apply these criminal laws to official conduct, the court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official unofficial line. And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. Organizing fraudulent slates of electors, creating false documentation that says I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct, and I think that the D.C. Circuit in the Blassingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
there's an allegation in the indictment that has to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were use of the president's official power. In many ways, we think that aggravates the nature of this offense. Seeking as a candidate to oust the lawful winner of the election and have oneself certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators alleged in the indictment are private. But for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. And so in the Department of Justice episode, it occurs very late in the election cycle after many other schemes had failed. And at that point, the petitioner is alleged to have tried to pressure the Department of Justice to send false letters to the states claiming that there were serious election irregularities and that they should investigate who they certified as a president.
Okay, so what's happening is the president is this is the Supreme Court, by the way. They've gone all the way up to the Supreme Court to ask, is the president immune from everything? Is he immune from all of his all of the crimes they committed by having the secret documents in his house? You know, the cases in his house that were in his bathroom, up on a stage, like all over his house at Mar-a-Lago. And with the president I'm talking about is President Trump. The President Biden also had some stuff over at his house too, but he didn't know he had them. What? I mean, it's ridiculous. Well, if he's too old to know, don't know that he had those, why is he president? It's ridiculous. Okay, they're both corrupt. But anyway, he's there. This the Supreme Court trying to say if do presidents are they immune? Are they immune from all of our laws? If so, what's to stop them? You know, what's to stop them from hypotheticals? And there's all kinds of hypotheticals. I can't mention most of them because they're terrible. But that's where we are. That's what this is.
This was
to the question that we're asking here.
So this is one of the most difficult questions for the Department of Justice, and I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer to the question, was he acting in the capacity as office seeker, or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations. And the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Let's ask the chat.
Thank you.
Justice Gorsuch?
If you did, though, I just wanted to confirm, I thought I heard you thought that the Blassingame framework was the appropriate one. Is that right?
Largely, yes, Justice Gorsuch. We agree with the idea of the distinction between office holder and office seeker. We also agree that if it's objectively reasonable to view the activities as those of office holder, then the Fitzgerald immunity kicks in. I think we would look more at the content of the actual interaction in order to make that determination than Blassingame suggested, at least on the facts of that case, might be appropriate.
Can you give me an example of what you have in mind? I'm just trying to understand what
I am the line, and that is the
you're
truth.
suggesting.
So Blasingame adopted, generally very favorable pro-government
The only line I bow down to is
we
the line of
endorse
Judah.
in private civil cases.
I don't know what you are.
Not here, because we don't think that Fitzgerald applies in the criminal
I
context.
understand that, but
are we going to
putting
hold
that
them accountable or
aside,
not?
the
Facts,
distinction
Bailey.
between official act and private office seeker,
Yes.
their test is, you think, good enough for government work?
On this one, the department hasn't taken a next step since the Blasingame decision, but let me offer a few thoughts that Justice Gorsuch I think might clarify it. The Blasingame decision focused on objective contextual indications to try to see whether the president was acting as a campaigner as opposed to an office holder.
Yeah.
I think that decision can also be made by looking at what the president actually said. And let me illustrate that with an allegation that I think my friend talked briefly. In one of the interactions between petitioner and a state official, petitioner is alleged to have said, all I needed you to do is to find me 11,000 votes and change. I think if you look at that content, it's pretty clear that petitioner is acting in the capacity as office seeker, not as president, and we would look at that content.
Okay. But the test, I'm just focused on the legal test.
Correct.
I'm not hearing any objections to it.
Other than I think that the D.C. Circuit placed more content consideration off limits than I would.
Okay, all right. And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected as such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in reelection.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of
That is
motive.
right.
Okay.
That is right.
All right, so then we're in the non-core powers where we're fighting over. What role do motives play there? I mean,
I do appreciate the donuts.
One could remove an appointee that, well, first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seala Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And a restriction,
put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes, to enrich yourself, for example.
Well, bribery, all right, yes. but that's what I was wondering. Do motives come into the core power analysis or not? And now I'm hearing, I thought I heard no, and now I'm hearing maybe.
I think maybe might be a little bit more appropriate because it's not involved in this case. The department has not had to take a position on exactly how these core powers would be resolved under an as-applied constitutional analysis. None is involved in this case.
And I guess I'm wondering, and I'm not concerned about this case so much as future ones too, but these non-core powers and maybe core powers where a president is acting with at least in part a personal interest in getting reelected. Everything he does, he wants to get reelected. And if you're allowing in motive to color that, I'm wondering how much is left of either the core or non-core powers.
So I would be fine with carving that out and deeming that to be something that's intrinsic in our electoral system. We're not talking about applying criminal law to somebody who makes an announcement that this program will be good for the United States, and somebody could come along and say, well, you really did it to get reelected. Leaving aside whether any of that violates a criminal law, I know that the next question is assume that it does. I'm doubtful that it in fact does, because I don't think criminal laws generally operate on motives as opposed to objectives and purposes. But
all right, intentions. I mean, you can frame a motive as an intention, and an intention as a motive, as you well know, every day of the week.
Yes.
So let's put that aside.
I understand. Well, putting that aside, that really, to me, falls in a very different category, and it is also possible.
So there's some motives or intents that are cognizable and others that aren't. I mean, it's awkward, right, when we look back at like the injunction back to Marbury in the early cases. You can't enjoin a president.
Yeah.
Also meant you couldn't hold him in contempt. Right?
A sitting president.
For sure.
Just, Gorsuch, right? Can I try one more time?
Well, let me just spin this out just a second.
Frank, where are you from?
Okay. Right, and it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, in Nixon versus Fitzgerald, that's something courts shouldn't get engaged in, because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other
we would have had a much different country.
Reactions, thoughts? Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I
signed the bill
don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
Guys, take it easy.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the ages.
Yes, and I think I would start by looking at the statutes and seeing what restrictions they do place on the president's conduct. And for example, the statute that prohibits fraud to defeat the lawful functions of the United States. The statute defines what the purpose is that the defendant has to have in mind. It has to be to defeat something that the United States is doing, and it has to be by deception. I don't think that that gets us into the realm of motive hunting in the area where we are as concerned, I think, as the court would be about doing something that would undermine the presidency and the executive branch. And 1512C2, we may have different views on the clarity and the scope of that statute. I think if the court does interpret corruptly as involving a consciousness of wrongdoing and elevates that to consciousness of illegality, then we're in a different realm. Wanting to get reelected is not an illegal motive, and you don't have to worry about prosecuting presidents for that.
Yeah. Okay. Thank you, Mr. Dreeben.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produced in a particular case. You've emphasized many times regularity, the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes. My wife is pregnant, so
that's the concern going forward, is that the system will, when former presidents are subject to prosecution, the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. The proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
I think President Reagan, President Bush, and President Clinton, whether rightly or wrongly, thought contrary to what you just said.
I think nobody likes being investigated for a crime, but it didn't result in the kind of vindictive prosecutions that I think Your Honor is raising as a possibility.
Yeah.
We have a different system now. I think there was a consensus throughout Washington that there were flaws in the independent counsel system. It lapsed. We now are inside the Justice Department with full accountability resting with the Attorney General. So the special counsel regulations now don't operate the way that the independent counsel regulations do. And this court would have something to say about it, I think, if the independent counsel statute were revived. I'm not sure that anybody is in favor of that.
Right. No, I was just saying this is kind of the mirror image of that, is one way someone could perceive it. But I take your point about the different structural protections internally. And like Justice Scalia said, I do not mean to suggest anything of the sort in the present case. I'm not talking about the present case, so I'm talking about the future. Second, another point, you said, talked about the criminal statutes. It's very easy to characterize presidential actions as false or misleading under vague statutes. So President Lyndon Johnson, statements about the Vietnam War. Say something's false. Turns out to be false that he says about the Vietnam War. 371 prosecution after he leaves office?
I think not, but this is an area that I do think that merits some serious and nuanced consideration. Statements that are made by a president to the public are not really coming within the realm of criminal statutes. They've never been prosecuted. I realize that the court can say, well, what if they were? And then I think you get to what I would regard as a hard constitutional question that would probably guide the court away from trying to resolve today, although I do think it's very different from our case and distinguishable in important ways. But you're dealing here with two branches of government that have a paramount interest in the integrity and freedom of their interactions with each other. On the one hand, the president, of course, should be very free to send usually his cabinet officials and sub-cabinet officials to testify to Congress, to provide them with the information needed to enact legislation and to make national policy. And we're very concerned about anything that would trammel that. On the other side of the equation, Congress has a compelling interest in receiving accurate information, and at the very least, not information that is intentionally and knowingly false. Right. That would pollute the legislative process.
How about, I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad, and it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute, because it talks about unlawful killing, did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
Thank you for your answers.
Justice Barrett?
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blassingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me.
Somebody outside of the
agree or disagree?
Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive acts to me. There is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary. Because in some of these instances, when the president takes such actions that, the court's been asking you, might this result in criminal prosecution? You say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function?
And therefore, I acted lawfully.
Therefore, I acted lawfully and I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then an interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get-out-of-jail-free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority we're calling it a defense, but under many statutes, it's actually an exception to liability itself. And what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? And I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here. Other kinds of defenses, though, really do intersect with the general issue. And for those, I have a much greater time seeing how the court could implement that. And would there be costs in going to trial? Yes. There is no perfect system here. We are trying to design a system that preserves the effective functioning of the presidency and the accountability of a former president under the rule of law. And the perfect system that calibrates all of those values probably has not been devised. I think that the system that we have works pretty well. Maybe it needs a few ancillary rules. Okay. It is different from the radical proposal of my friend.
I agree. Let me ask you about state prosecutions. Because if the president has some kind of immunity that's implicit in Article 2, then that immunity would protect him from state prosecutions as well. A lot of the protections that you're talking about are internal protections that the federal government has, protections in the Department of Justice, which obviously are not applicable at the many, 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 many state and local jurisdictions across the country. What do you have to say to that?
So that raises a Supremacy Clause issue, and the court would run a Supremacy Clause analysis that would probably start with basic principles like McCulloch versus Maryland. The states do not have the authority to burden federal functions, and would then kind of move through in Nagel, where the court said that a state murder prosecution of a federal official guarding a Supreme Court justice and who fired a shot was not permissible. If the court thought that you needed a more categorical rule for the states, I think the Supremacy Clause certainly leaves it within the court's prerogative to determine that the president, unlike all other officials, deserves more of a robust federal defense than what I have just described.
But it would still be a defense in the states. It wouldn't be, I mean, well, that's my point. Like, yeah. It's one thing to say, well, the president, they're not going to be these prosecutions that are politically motivated, the things that Justice Kavanaugh was referring to that might be the danger of this system, one thing that we have to worry about. That might not carry the day, but, that's a concern. It's totally different when you take it outside of the Department of Justice and its structures, and then you throw it out elsewhere. The idea across the states, the idea of an immunity, I think, has a lot more purchase if you're talking about something that protects the former president from standing trial and the state and local level.
So I don't know that you would have to design a system in which the president would have to stand trial at the state and local level. It's certainly within the court's authority as a matter of Supremacy Clause law to find an immunity. But we have been talking here about, at some length, on the distinction between official acts and private acts.
Like, share, and follow.
That will have to be determined by some sort of a process. Any immunity defense that the court announces can still be met by a state assertion that we're prosecuting private conduct. You're going to have some process. I think having some legal process is not a reason to cast aside a nuanced system that actually looks at what protections are necessary as opposed to what would provide the absolute maximum insulation for former presidents, even if we acknowledge that it's highly prophylactic.
Totally agree, and I wasn't actually contrasting the absolute immunity rule. I was saying that if there was some sort of official-private, there are consequences towards about making immunity. Okay, and since you bring up the private acts, this is my last question. So I had asked Mr. Sauer about on page 46 and 47 of your brief.
Yes.
You say, even if the court were inclined to recognize some immunity for a former president's official acts, it should remand for trial because the indictment alleges substantial private conduct.
Yes.
And you said that the private conduct would be sufficient?
Yes.
The special counsel has expressed some concern for speed and wanting to move forward. So, the normal process, what Mr. Sauer asked, would be for us to remand if we decided that there were some official acts immunity, and to let that be sorted out below. It is another option for the special counsel to just proceed based on the private conduct and drop the official conduct?
Well, two things on that, Justice Barrett. First of all, there's really an integrated conspiracy here that had different components, as alleged in the indictment, working with private lawyers to achieve the goals of the fraud, and as I said before, the petitioner reaching for his official powers to try to make the conspiracies more likely to succeed. We would like to present that as an integrated picture to the jury so that it sees the sequence and the gravity of the conduct and why each step occurred. That said, if the court were to say that the fraudulent elector scheme is private, reaching out to state officials as a candidate is private, trying to exploit the violence after January 6th by calling senators and saying, please delay the certification proceeding, is private campaign activity, we still think, contrary to what my friend said, that we could introduce the interactions with the Justice Department, the efforts to pressure the vice president, for their evidentiary value as showing the defendant's knowledge and intent, and we would take a jury instruction that would say, you may not impose criminal culpability for the actions that he took. However, you may consider it insofar as it bears on knowledge and intent. That's the usual rule with protected speech, for example, under Wisconsin versus Mitchell. My friend analogizes this to the speech or debate clause, but we don't think the speech or debate clause has any applicability here. It's a very explicit constitutional protection that says senators and representatives shall not be questioned in any other place. So it carries an evidentiary component that's above and beyond whatever official act immunity he is seeking. And the last thing I would say on this is we think that the concerns about the use of evidence of presidential conduct that might otherwise be official and subject to executive privilege is already taken care of by United States versus Nixon. That balances the president's interest in confidentiality against the need of the judicial system for all available facts to get to the truth.
Because I saw it about an hour ago.
Once that has been overcome, we submit that evidence can be used even if culpability can't rest on it.
Thank you.
Justice Jackson?
Just to pick up where Justice Barrett left off, I think I heard you say that even if we decide here something, a rule that's not the rule that you prefer, that is somehow separating out private from official acts and saying that that should apply here, there's sufficient allegations in the indictment, in the government's view, that fall into the private acts bucket that the case should be allowed to proceed.
Correct.
Because in an ordinary case, it wouldn't be stopped just because some of the acts are allegedly immunized, even if people agree that some are immunized. If there are other acts that aren't, the case would go forward.
That is right.
All right. Going back to the clear statement argument, I'm struggling with that argument because my understanding was that when a charged criminal statute is read narrowly in the presidential context to not apply to the president, a constitutional question is being avoided. So that you're doing that to avoid having to deal with the constitutional question. So what is the constitutional question that is being avoided in those kinds of situations?
A serious one. This is just an application of this court's ordinary construction of criminal statutes, that if there is an available interpretation that would avoid a serious constitutional question, the court's preference is to—
Right, and the nature, I guess I'm going at, my understanding is that what is being avoided in that situation is the question of whether a former president can be held criminally liable for doing the alleged act that is being asserted in that statute consistent with the Constitution. So we look at the statute, it's got some elements in it, and we are saying, well, geez, if this statute and those elements apply to the president's conduct in this situation, we'd have to answer the question, can the president be held liable consistent with the Constitution for that behavior? Is that right?
So the first step in that analysis, I just want to—
Yes,
please. But the first step is there ambiguity? And these statutes apply to any person. They apply to whoever. There's no ambiguity in those phrases. This court in Nardone versus United States concluded that similar words, any person, apply to government officials.
All right, well, let's just assume that I guess I'm just trying to get at, we're avoiding a constitutional question if we do that in the ordinary case. And what's confusing to me about this case is that we're not being asked to avoid the constitutional question. In fact, the question of whether or not the president can be held liable consistent with the Constitution or does he have immunity is the question that's being presented to us. So I don't understand how the clear statement kind of analysis even works. It seems completely tautological to me for us to hold that presidents cannot be prosecuted under any criminal statute without a clear statement from Congress to avoid the question of whether or not the Constitution allows them to be prosecuted. We'd have to have a reason, right? I mean, we'd have to have a rationale for applying the clear statement rule.
I think the court would have to have some rationale that's not evident in either the existing doctrine or the text. And just one data point for the court in thinking about how the clear statement rule works. In United States versus Sun Diamond, a case about gratuities that the court is probably familiar with, Justice Scalia wrote an opinion for a unanimous court in which he used a hypothetical about what would happen if the president received a sports replica jersey at a typical White House event. Would that violate Section 201C? And the court offered a construction that it had to be for because an official act to avoid that problem. I think if there was such a well-received understanding that presidents are not included in general federal criminal law, unless the president is specifically named, which he is not in Section 201, Justice Scalia would have thought of that, and some member of the court would have reacted, and none did.
All right, let me go on to ask about what you take the petitioner's position to be in this case, because we've had a lot of talk about drawing the lines. Justice Kavanaugh, Justice Gorsuch suggested that we should be thinking about Blassingame, and that within the, first we have private versus official, and then within official now we have something about core acts versus other acts as we try to figure out, you know, at what level the president is going to have immunity. But I took the petitioner's argument in this case not to be inviting us to engage in that kind of analysis. I thought he was arguing that all official acts get immunity. And so I didn't understand us to be having to drill down on which official acts do. And so my question is, why isn't it enough for the purposes of this case, given what the petitioner has argued, to just answer the question of whether all official acts get immunity?
That is enough, and if the court answers that question the way that the government has submitted, that resolves the case. I want to make a clarification that I may have left the court with some uncertainty about. The official act analysis that my friend is talking about is the Fitzgerald versus Nixon outer perimeter test, which is extremely protective of the president. It's not looking at core versus ancillary. It's saying everything the president does is a target for private civil lawsuits. That is not a great thing, and therefore they are all cut off.
That's an absolute immunity kind of concept, right? Anything that's official in the outer perimeter is not subject to liability.
That is right.
And so we don't have to then go, well, okay, we have the bucket of official, now let's figure out which within that might be subject to liability, not on the theory of absolute immunity, correct?
Neither on the theory of absolute immunity or on our theory. On his theory, everything's protected. On our theory, there is no immunity, but this is where I would draw the distinction. There are as-applied constitutional challenges that you run through the Youngstown framework and this court's customary method of analysis, and you determine whether there's a infringement of Article 2.
So what you're saying is, even if we reject the absolute immunity theory, it's not as though the president is, you know, doesn't have the opportunity to make the kinds of arguments that arise as at the level of, you know, this particular act or this particular statute has a problem in retrospect. I think I hear you saying we should not be trying to, in the abstract, set up those boundaries ahead of time as a function of sort of blanket immunity, allow each allegation to be brought, and then we would decide in that context.
Yes, with the additional note that petitioner has never made that argument, and I think it would be up to a district court to decide whether to go that route at this point in the litigation. He's put all of his eggs in the absolute immunity basket.
All right, and if we invite, you know, if we see the question presented as broader than that, and we do say let's engage in the core official versus not core and try to figure out the line, is this the right vehicle to hammer out that test? I mean, I'd understood that the most, if not all, but most of the allegations here, there's really no plausible argument that they would fall into core versus not, such that they are immune.
We don't think there are any core acts that have been alleged in the indictments that would be off limits as a matter of Article 2.
So if we were going to do this kind of analysis, try to figure out what the line is, we should probably wait for a vehicle that actually presents it in a way that allows us to test the different sides of the standard that we'd be creating, right?
So it was muted.
I don't see any need in this
I thought it was a troll at first, but then when a lot of people
All
were
right, the
saying
final
it,
sort of
I was like, there's no way this is a troll.
questions that I have to do with what I do take as a very legitimate concern about prosecutorial abuse, about future presidents being targeted for things that they have done in office. I take that concern. I think it's a real thing. But I wonder whether some of it might also be...
Okay, what I said is they're trying to figure out, this is the Supreme Court, by the way, if President Biden is immune from all of his past crimes and future crimes because he's president. Also, that would go to Obama, Bill Clinton, Bush, every one of them that's still alive, including Biden. And that's what they're arguing right now because, and this all has to do with the January 6th. If I say insurrection, people get mad, but whatever. And then also the boxes of classified information that both Biden and Trump had. Trump had significantly more, and Biden said that he forgot about it. That's our precedent? Anyway, whatever. They're both trash, and that's what this is about.
Mitigated concern about...
People say that I'm biased because of my Trump hate. Trust me, I got hate for Biden too. Tons of it.
Knows that he does not have to ultimately follow the law because there is really nothing more than, say, political accountability in terms of impeachment. I mean, we have amicus briefs here from Professor Lederman, for example, who says, a president would not be prohibited by statute from perjuring himself under oath about official matters, from corruptly altering, destroying, or concealing documents to prevent them from being used in an official proceeding, from suborning others to commit perjury, from bribing witnesses or public officials. And he goes on and on and on about the things that a president in office with the knowledge that they have no criminal accountability would do. I see that as a concern that is at least equal to the president being worried, so worried about criminal prosecution that he, is a little bit limited in his ability to function. So can you talk about those competing concerns?
So, Justice Jackson, I think it would be a sea change to announce a sweeping rule of immunity that no president has had or has needed. I think we have also had a perfectly functioning system that has seen occasional episodes of presidential misconduct. The Nixon era is the paradigmatic one. The indictment in this case alleges another. For the most part, I believe that the legal regime and the constitutional regime that we have works, and to alter it poses more risks.
Thank you.
Thank you.
Thank you, counsel. Rebuttal, Mr. Sauer?
I have nothing further, Your Honor.
Thank you, counsel. Counsel, the case is submitted.
The Honorable Court is now adjourned until Thursday, the 9th of May at 10 o'clock.
Okay. That's it, guys.
You have been listening to arguments before the U.S. Supreme Court about a novel legal argument being put forth by former President Trump's legal team, which is that he cannot be prosecuted for things he did while in office because presidents have absolute or near absolute immunity for official acts. A federal appeals court ruled against that argument, and today several of the Supreme Court justices seem skeptical of the broad claim of criminal immunity. They raised various scenarios, assassination, a coup, or bribery, and asked if a president is immune for criminal liability, what's the difference between a president and a king? But several of the conservative justices also seem to suggest that the role of president is unique and might require additional protections. The Supreme Court's decision would determine whether a criminal trial can go forward. Trump has been charged with plotting to overthrow the 2020 election. I want to bring in now Jessica Levinson. She is CBS News legal contributor and Loyola Law School professor. Jessica, what are your takeaways from these oral arguments this morning?
Live last night.
Absolutely fascinating discussion by the justices about the power of the presidency and where that power ends, where there could potentially be immunity from criminal prosecution and where there is no immunity. And I think what you heard is the justices really struggling with where to put the line. I don't see the justices. I didn't count to 5 for saying that there would be absolute immunity from criminal prosecution. And I similarly did not count to 5 for finding.
We ain't watching these people. Ugh. I can't take it. I can't take it. What a bunch of monsters. Actually, let me call my wife real quick. Call Vera Knight.
Calling Vera Knight, mobile.
Love my wife. She's pregnant, by the way. We're having a kid. That would be our fourth kid. Hey, babies, are you upstairs?
Yeah, I've been upstairs.
What are you watching?
I am watching X whatever, but I already seen it.
Okay, can you do me a favor? I gotta use the bathroom. Is there any way you could sit down here and talk to the chats?
Yeah.
Thank you, bubbies. Did you want to get some lunch, or what are you thinking?
Oh, I'm good. I just got done eating.
No, it's fine. I love you.
Maybe tomorrow, is that okay?
Are we immune from paying taxes? And guess what? If you're president, you are. You're immune from everything if you're president, I guess. Yeah, that sounds good, but I love you, babies. You guys are so cute. Thank you so much, stars. Appreciate you. All right, love you. Bye-bye. All right, yeah, just sit here so that they don't, do the crazy stuff that they do at TikTok. You want to talk to them? You don't have to. I mean, you can just sit here. And then there's this chat, too, that's both back there.
Oh, cool. Hey, y'all. How are y'all? Y'all doing good? Hi. How are y'all doing? Oh my gosh, I can hear myself. Hey! I'm gonna take off. The thing is a little too loud. Aw, y'all are so sweet. Thank you, Madison. Thank you so much, Live Change. That was really quick. Thank you so much, Armenia. Armenia? I think I said it right? I'm so sorry if I said it incorrectly. Beautiful name. Hey, how is everybody? Morning, afternoon, or night? I'm not sure where y'all are. Hope everyone is doing good. And thank you so much, Miss Collin. Thank you, Miss Madison. Good. Oh, so there's 3 chats going.
Yeah, okay, so I've got my chat on my...
I didn't see y'all, I'm sorry.
That's YT, that's TikTok, and then I've got one on my phone, or I did have one on my phone for Twitch.
That's awesome. Y'all have a good day.
Love you, baby. Oh, you're awesome. She's so sweetums. All right. Did they decide? No, they're going to vote, I guess. I don't know. Who knows? I'm sure we'll find out later. Quit spreading misinformation. TikTok is a worldwide app. They do not have to sell. Right, they don't. If they don't want to, they can throw deuces and leave the American market if they want to. Yeah, yet again, what I reported is might be considering. We don't know. These people get so mad. And actually, let's go to X real quick. We could go to Dexerto. And President Biden has signed, okay, that was yesterday. Couple of TikTok found a secret room 20 feet under their house. Oh, yeah, I saw that. That was really interesting, actually. This was on my FYP. It was a secret room 20 feet under their house, dude. It's crazy. Okay, ByteDance has denied reports of their plan to sell TikTok. So it was denied. It was denied. It's a fake plan. So I'm going to go ahead and take that down. According to the information, however, internal sources say that ByteDance is exploring scenarios for selling off its majority stake. Okay, so wait a minute. So 57 minutes ago, ByteDance has denied reports. According to the information, however, internal sources say that ByteDance is exploring scenarios for selling off its majority stake in TikTok. The report claims that the company wants to sell to someone outside of the tech industry. Oh, okay. So it's just a scenario. ByteDance has denied reports of their plan 30 minutes ago. According to the information, however, internal sources say that ByteDance is exploring scenarios. Why? Why would they sell it? Does anybody know why they would sell TikTok? I mean, think about this. They have 1 billion users worldwide, right? R-Truth is also live. Dude, R-Truth is amazing. They have 1 billion users worldwide. Worldwide. Why would they need to sell it? They have 170 million here. They have American tax, the ad money. But that's it. They could just as well do that anywhere else in the world. I don't know about that. Everything has a price. I guess. I mean, yeah. But they're exploring scenarios for selling off its majority stake. But who outside of the tech industry could buy it? Who? The price would have to be astronomical. By the way, they wouldn't be selling the algorithm. No, Facebook's in the tech industry. X is in the tech industry. What's with the sad piano music? I just add that. So they decided to sell. It says here, according to the information. So this is probably people on the inside, either from Douyin, which is the Chinese company, TikTok. Maybe somebody that works there. Maybe they've had meetings on this that are saying that they're going to be, it's an internal source, so they work for them, saying that ByteDance is exploring scenarios for selling off its majority stake in TikTok. The report claims that the company wants to sell to someone outside of the tech industry. However, they're fighting this in federal court. So this would be something outside of the federal, because like if they win in federal court, they're not selling it. They're not selling it if they win in federal court, which they might do. However, if they do sell it, or, who knows? Who knows what ByteDance is thinking, because it's only 20% owned by China. The rest of it is owned by American investors. Like literally, American investment group make up, 60% of it? The other 20%, I think, is just, who knows? Middle will get a gauntlet of social media, a monopoly of social media's facts. That's a problem, by the way. True. Yeah. The Miss Harden. Thank you guys, by the way, for all the donos. But yeah, so Dexerto, 57 minutes ago, which is now like an hour ago. Yeah, an hour ago. ByteDance has denied reports of their plans to sell TikTok. According to the information 34 minutes ago, so earlier. However, the internal sources say that ByteDance is exploring scenarios for selling off its majority stake. So they don't want it to just become a useless app, I guess. They want to see how much they could get from it, probably. Which would, yeah. I mean, what do you guys think? Let me ask this question. Let me put this question to a vote. Because I love asking you guys questions. So go ahead and text poll here. Is anyone above the law? Should TikTok sell to an American company? Yes, no. I'm going to make it that easy. Save. And we're going to go ahead and start that right now in the comments. What do you guys think? Should TikTok sell? We're getting a bunch of no's. We're getting some yeses. I don't think they should. Because I think they're going to win in federal court. I do. You said they won't sell. Yeah, but now there's speculation from inside information. See, I don't know if you guys know this, but when I report the news, I can only go off of the news that I have. I'm not a psychic. Like when China says, "Hey, we're not selling ByteDance," I go off of that news. How are you? I'm doing fantastic. How are you? Do you think TikTok will win the fight at court? I do think so, yes. No, or else our voices are going to be censoring us. Well, yeah, the United States loves to censor us. That's what they do. Doubt they'll win. National security overrides everything pretty much. Actually, with Homeland Security, what was that called? It like changed everything forever. You know, like it gave the United States unfettered access to all of our phones and information. Patriot Act, that's the one. Patriot Act. Yeah, we need to appeal that. Day one, I would get rid of the Patriot Act. If I was president, I would sign it as an executive order to get rid of that thing. It gave unfettered access to us, to the United States government, which I don't trust. TikTok needs a strong legal team. Do we still get to use the app when TikTok do win the fight at court? Of course. Even if they don't, it sounds like they're thinking about selling it. Maybe 170 million lives. Why rid of app? Yeah, facts. It was abolished. The Patriot Act was abolished. Nice. Bring back Roe versus Wade. That's a hot button issue, but you know, if I give my opinion, I'll be ostracized for it. I want humans to survive, especially moms. I want moms to survive. You understand that? Moms to survive. And since it's abolished, a lot of moms are going to end because they need certain things that they can't get because Roe versus Wade was abolished. Heaven forbid. Or how about kids that have been taken advantage of now have to raise the kids of possibly their own family, of random strangers? But, you know, it's a human life. You're right. What about the moms? Biden just lost my vote. Hey, I'm not voting for that guy. I'm definitely not voting for Trump, though. I'm not voting for either one of them. I will vote for everybody else in that section. Actually, I'll look for whoever's running against him and vote for them. Whoever's running against those two, they got my vote. Kennedy, I don't even know who he is. I don't know what he stands for. I'll vote for that guy. And whoever voted for the TikTok ban, I will look them up and vote against whoever's running against them. That's it. That's how I'm voting this year. Oh, is a no vote for Republicans also a vote for blue? What are you talking about? If you don't vote for Biden, you're voting for Trump. Well, if I don't vote for Trump, am I voting for Biden? What are you talking about? That is the exact same. You actually think that makes sense. It doesn't make sense. You act like Trump's winning is a foregone conclusion. You could literally say that for either candidate. It is ridiculous. Yes, I'm a caseworker. Have seen too much ugliness. Women healthcare is vital. Facts. People don't want to talk about what is this? Has been age restricted. Who is that? Somebody's trying to get in my live? Why? I don't do these. I don't do the fights. We don't vote for no president. Never have, never will. Listen. I vote every time. And I'm not going to lie to you. I used to be a huge super Trump fan. I voted for him. I voted for Trump. I voted for Trump twice. Because last time, I don't know. But they're both sickening human beings. They really are. I disagree with Biden now more than I ever have. Why did you change your mind? Look at him. Look at what he's done at his house. Not only that, but okay. under him, we didn't have any war. We had a lot of what I would think good things going on. But the guy was a maniac. And I'm definitely not voting for him now. But what Biden has done is caused our country to have the worst inflation in human world ever possible. And they're saying that's Trump's fault. It probably is. But he's allowing it. And he's sending these hundreds of millions of dollars to Ukraine, where his son used to work. In one of the most corrupt governments that the world has ever seen, in Ukraine. We're funding that. Those people over there don't want Zelensky. But he's got a gang in there that allows him. We will get a conservative if young people vote. If young people vote, Biden's cooked. I'm just letting you know. Democrats and Republicans, they're both evil. Get off the internet, Trump boy. Hey, you first. Is Trump your God, Kendall? Do you bow down to Trump? He's an evil human being. Voting is a joke. Facts. It's not about the votes. Facts. Leave out my whole text. What whole text? What are you talking about? What are you talking about? Trump is my savior? Okay. I bow down to only Jesus. That's your God. Jesus is my God. That's your God? What? Biden? Biden's your God? Kendall? What are you talking about? Which one's your God? Biden or Trump? Which one? I don't pray to those guys. Yeah, Jesus. Jesus is my only God. Amen. It is needed most we get along and stop fighting with other countries. We need the money here. And yet we're fighting wars in Ukraine to one of the most corrupt countries in the world. We're funding 33,000 people, mostly civilian mothers and children, bombed. That's what we're funding right now. 26 million of that's going to Israel, to Netanyahu, which the people in Israel, they revolt in the street. They're having protests against that guy. But let's give them money. Let's give Zelensky money. Where's the money for us? They have healthcare, free healthcare, by the way, universal healthcare over there in Israel. None here. Stop the wars. Stop them. The Republicans love war. The Democrats love war. Both of you. Shame. Trump, shame. Biden, shame. You guys are shameful. And I know, guys, I know you bow down to Trump and Biden as your gods. They are shameful human beings. Shameful. Everyone in that Senate, everyone in that House of Representatives, outside of a few, very few, shameful human beings. And they will all stand in front of God and be judged. Every single one of them. That's it. TikTok might get sold. Overwhelmingly, 35-14. TikTok should not sell to an American company. There you go. Last bill was brought to you in part by Raytheon, Lockheed Martin, and BlackRock, and Vanguard. Yeah. All right, well, so yeah, there you go. But ByteDance has denied the reports. There we are. Encourage your viewers to share. Okay, guys, like, share, and follow. Like, share, and follow. Appreciate y'all. The United States military needs to arrest Washington, D.C. now. You probably. They're all treasonous. Talking about World War II and Vietnam. All right. The next video we're going to be looking at, because I don't know if there's any more information on this. Let's check out TikTok latest. It's just TikTok reposts? All right. I don't want to scroll down too far on this app because it gets a little crazy. Let's go ahead to let's go to Google. Actually, let's go to YouTube. What are they talking about? Oh, they're still talking about that? Nah, it's done. It's done. What have my kids been watching? Okay, so that's me. That's One Piece. Thursday Morning Cafe. Oh, guys, you guys should be watching this guy. He's awesome. Ali Coco. And you should be watching JD Delay. Amazing dude. I was in an Anime Man movie or a video recently. Check this out. Let's check them out real quick.
Bro, just ask her out.
Dude, I can't. I'm too scared.
Bro, just ask her out.
Dude, I can't.
It was their actual video just a couple of days ago, I think. We asked over 100 TikTokers what the best anime ever was.
We're always fighting over what the best anime of all.
Or should I say the best and most fun stories?
It was anime. Kind of just holds a special place in my heart because it's my first anime I ever watched.
And the greatest anime of all time is Fullmetal Alchemist Brotherhood. Not regular Fullmetal Alchemist. It has to be Brothers in the Hood. Fullmetal Alchemist Brotherhood. This one right here. If you have another opinion, it doesn't matter. And yes. Because it's a fact. Yeah.
Our favorite anime of all time is gonna have to be One Piece.
My favorite anime is Hunter x Hunter, baby.
Yo, we in the Japanese bathroom with it. So, what is my favorite anime of all time? I'm going with Neon Genesis Evangelion.
I'm Bald News Network, and my favorite anime is Redo the Healer.
Okay, what they cut out here is I was like, nah, I'm just kidding. It's Dragon Ball Z. But they kept this part, which is funny, because Redo the Healer is like one of the worst animes of all time. By the way, it's like really well put together, but it's terrible. It's all about grape. Just take out the G. That's what it's about. So I was joking, but they kept it in here as just that.
So my favorite anime.
Yeah, see, that's they don't put it. They just added that. So, yeah, it was a joke, but I was in an Anime Man video, and that, by the way, that video I sent that to them early 2023. No, it was last year. Because it's taken me a long time to get... No, because I sent it to them, it was like at 1.7 million. They put it at 1.9. I'm 2 million now. Dragon Ball Z for sure. Demon Slayer. Yeah, to Redo Healer. Yeah, don't watch that, by the way. That's terrible. Black Sands, thank you so much for the donos, man. Go follow Black Sands. But it's crazy. It's crazy. Don't watch Redo the Healer. Don't do it. Let's go ahead to iShowSpeed. Sketch. All right, so this is from Live Speedy, but this is iShowSpeed's actual. Okay, so we'll go ahead and watch this. So what I mostly cover, I'm now covering politics. I didn't even want to, but I've been thrown into it because I don't trust either side. I think they're both trash. But my major content is influencers. And Sketch yesterday, what's up, brother? Like he's everywhere. But he himself got injured yesterday doing a combine. iShowSpeed is he's a freak of nature. He's got athletic potential. He got a 4.4. His jump is insane, and he's only like what, 5'7", 5'8". He's not that tall. But he's got insane athletic. Maybe actually is he 5'10"? Let's find out. How tall is iShowSpeed? He's 5'9". He's 5'9", 5'9" tall. So he's 2 inches taller than Aiden Ross. That didn't take much. Cristiano Ronaldo is 6'2". I thought he was way taller. Oh, dang. Okay. It's the black jeans. What are we talking about? Anyway, let's go over here. We're going to start watching this. So I'm done with the politics. We're now going to be watching iShowSpeed. Just letting you guys know. It is an hour and 34 minutes. Okay. This was supposed to be an all-day stream going into an NFL combine. But it only ended up being an hour and 34 minutes because Sketch ended up tearing his hamstring. So we'll watch that now. And the sound's about to come on anytime.
Okay, you're live, bro. Right up.
Okay. All right. Got to give it a winner for Noti to send out. Oh.
What's your favorite plane?
Wait for it. Wait for it. Wait for it. Wait for it. Wait, are we live yet? And we are live. Let's go, brother. Spin out the W's in the chat for a little minute. Spin the W's in the chat. Gotta wait for Noti to send out. Let's wait for Noti to send out. Wait for Noti to send out. Today's the day. That's all I gotta say. Today's the day. Today's the day. Oh my God, I gotta piss so bad again, bro. That's the nerves. I gotta piss again, bro. I gotta piss again so bad.
Little nerves here.
Noti's out. Okay. All right, boys.
The update on Sketch is he okay? He did pull his hamstring. It's not a full tear. He just pulled it. I mean, Sketch most of the time is playing Rainbow Six Siege. IShowSpeed, I mean, he's like, he's a little bit athletic. He was training for boxing for a short period of time, but like he's incredibly fast. He like when he runs his 4.4 today, or when he did it yesterday, he was in slides. He ran a 4.4 in slides. It's incredible. So Jack Doherty already got thrown away. LMAO. That guy, oh my gosh, he needs to definitely go to jail. I don't trust that guy. I strained my leg out of leg curls weights. Facts. Someone please look up Michael McCowell's activity. The guy that once TikTok gone has invested in Meta. Oh yeah, of course they do. Okay, Toriyama, you're all about the black jeans and stuff. Very interesting.
Boys and girls, we got my man Sketchy here. You know what I'm saying? The brother. You know what I'm saying? Hey, look though.
Yeah,
see, look, man. We here at the NFL Combine, bro. Also, remember. Later on in the stream, we'll be linking up with some, you feel me, some NFL players too as well. So don't forget about that, bro. Shout out to the NFL too, bro, for making us happy. You know what I'm saying? You know, don't know how it is.
So a lot of that didn't happen because, as I said, Sketch gets injured.
So chat, spin up the W's in the chat.
And you do the next birthday filter.
Anyway, Sketch, bro, introduce yourself. You know what I'm saying? To my stream, bro. You know what I'm saying?
Sketch, at the Sketch Reel, you know, doing my thing with. We're doing a combine here. 40-yard dash to start.
Oh, what?
40-yard dash to start. You're in trouble.
What the fuck? All right, yo, chat. Be honest, bro. Who was winning in a 40-yard dash, bro? Me or him?
Oh, the Star
Look
Wars
at the shoes.
Yep, May
Chat,
3rd,
that's disrespectful.
Chat, be honest, bro.
That's disrespectful.
Who's winning in a 40-yard dash? Me or him, bro? Like, chat, let's be honestly real here, bro. Like, I'm not gonna lie, bro. You're not really like a.
I'm an athlete. Look at this. Look at what.
Like, what the fuck?
Like, I'm zipped up.
What the fuck is these?
Oh, come on. All-purpose trainers. What the fuck?
What the hell are those, bro?
Hey, what are those there? What are those, though? Just nice Crocs.
I got some grandpa.
They look like Crocs, but
these are grandpa shoes, bro.
Really? Grandpa's. They fuck from what I hear. Sorry for cussing.
Big bulky ass. Bro, he got these big bulky ass shoes. Okay, anyways, bro. Like,
he's slow on the block here. I got an engine that turns up hot.
All right.
So they were saying, Jenna, that that Speed was incredibly jealous of Sketch, and that's why he was treating him like that. Because like he's actually pretty aggressive towards him, but like he's also aggressive towards like all of his guests. He's aggressive towards Aiden. He's aggressive towards Kai. He was definitely aggressive towards KSI. Oh my gosh! And KSI and him are friends. But like Sketch, I don't think he was ready for this. I don't think he was ready. You know, probably not physically, but like definitely not for what IShowSpeed is. He's kind of just like he's just a ball of energy, you know.
All right. Okay. All right. Anyways, chat.
Playing a fucking soccer player here. Sorry for cussing, but
hey, it don't matter. Bully though. Anyways, chat. We're about to get straight into it, bro. You know what I'm saying, chat. Hold on, wait. Before we start, predictions on my 4.0. Prediction. I want to hear. Wait, what is it called?
40-yard dash.
Yeah, 40-yard dash. Prediction on my 40-yard dash. Before we go, let me hear them real quick, bro.
Over 5 seconds.
Let me hear my predictions on the 40-yard dash real quick, bro. Predictions before we go. Predictions real quick.
Did they really?
Lag? No way it's lagging. Are they trolling?
Settings for Fortnite have one for music notes? I had no idea.
Predictions real quick on a 40-yard dash. Prediction. What is it doing?
Chat, if it lags for you, close your chat. Just don't look at chat.
What does that mean, the YouTube out there?
Remember that chunking thing
they
showed us? They pushed that out, and now it makes it so annoying.
Oh, it's fucking up? Oh, okay, all right. 4.5? 4.67. 4.62. All right, man, what about his? I'm down like 6-7 seconds.
Oh, you better break that
right,
shit. They're glazing
shit.
you. 4.6. What the hell you think you
got
are?
4.4.
I'm fucking speed. That's
Oh,
what
I'm under 5.
Hey, I'm speed.
Speed.
Hey, Chad, turn this shit up, bro.
Hey,
Come on, bro.
let's go to the
Chad, turn this shit up, bro.
bench press. Bench press. I'm a locker room guy. I'm a locker room guy.
Chad, remember, y'all, we gonna have some NFL players come through. All right, man, come on. Wait, where should we sit? Yeah, I'll just sit right here. All right. I think you should sit in the... Yeah, you know, that's fine. Yeah, you're right. It's a 2-second ride. All right, Chad, I'm about to drive over here. We're about to drive to the combine, man. You know what I'm saying, bro? Shout out to the driver right here, man.
Thank you. Shout out to the NFL. Thank you. Shout out to my brother Speed. Thank you.
Is it actually lagging? Wait, hold on, wait. Let me hear real quick.
1224. Okay.
It sounds fine.
Oh, they love to complain.
Yeah, bro.
They love to complain there.
Nerdy internet girl. So 4,114 followers. Okay. Hey, I just want to give you a shout out because I get paid off of all the social medias. When this one's gone, that's only going to increase my pay rate. So I'm not going anywhere.
They on PC and they got chat open.
There you go. Yeah, they just got bad Wi-Fi. Not on us here.
I didn't think you would say anything.
That's his shit, bro.
You're just one of those trolls that types and then runs off.
You better beat me by more than a tenth of a second. Otherwise,
I'm not going anywhere, guys. I'm not going anywhere.
Bro, I'm not the dude.
I'm here, baby. I'm here.
I can't. I promise y'all, Chad, if y'all don't know, when I was a kid, they named me the fastest kid alive, bro. Because I used to do track. I used to be like,
okay, Blake, you got it.
You know, like state, you know, like Division I and shit.
Oh yeah.
Yeah, I was D1 in track and field.
Sounds like it sounds like you're lying, brother. I don't trust you.
You ready? All right, let's go. All right, man, we ready?
Gun rights because
Bro, I gotta piss. Yo, Chad, should I piss now or later, bro? I gotta piss so bad, bro. I promise you, dude. I don't know if I should piss now.
I break 5 seconds. I'm pretty happy with that.
I don't know if I should piss now or later. I genuinely don't know.
Couple Bud Lights in.
I can't wait.
Bro, Chad, tell me, yo, Chad. First time I meet this dude, right? We ate, right? This motherfucker ate 4 bottles of goddamn Bud Light. Who wakes up and just pop bottles of Bud Light?
Gatorade.
Like what?
Gatorade, you gotta keep it rolling. You know, keep it while it's hot. Strike while it's hot.
Prime, baby, prime.
What the fuck is he doing, bro?
It's okay. It's okay. It's the nerds. It's game day nerds.
It's totally safe. Drink prime.
It's hard, bro. All right. What the fuck was that?
No, it's what the fuck? What the fuck was that there? Sorry for cussing.
Did he just go? What are you, a seal?
No, I stretched. He's wearing sandals and sagging right now. I got my belt buckle
tight. Sagging.
They just proved it yesterday. Prime is good.
Oh, careful.
All right, bro.
Flashback.
All right.
Flashback Friday.
He got jokes. Okay, bro.
Here we go.
He got jokes. All right, here we go. Woo! Time to get running, huh?
Who's going first?
Time to get running, huh?
Logan Paul by going through everything that lawsuit
Time to get running. Time to get running. Who y'all want to go first, me or
Tommy,
Sketch?
the lawyer, went back over it.
Who y'all want to go first? Oh yeah, chat and my dad here, bro.
Pops.
Yes, sir.
Shout out Pops there.
Okay.
Look at Fly.
So Jimmy, after you get done crying, go look at all the evidence.
I'm not gonna lie, bro. Like, can I pee like at a corner or something?
After you get done crying, go look at the evidence.
Excuses.
One person each, and then
I know you're out there
Practice
crying.
one?
Should have wore a diaper.
So jaw?
I know you want to look at the evidence. Look at the evidence.
Like run, like actually run or jaw?
I'll do it like a test 40 basically. So you run a 40.
Ooh, Prime, delicious.
So you just, bro, what? Do you want me to just jaw?
No, do a full 40.
I ain't gonna lie, hold on, wait. I gotta pee, dead ass. Sorry, bro.
Oh, you are crying? Hey, Jimmy, I'm sorry, man.
Can we go to that bathroom again, please, real quick?
Joe Biden is guilty. Sit back.
I gotta pee bad.
Hero time travel and facts. Trump is not good. Facts, he's not.
40%. 40% there.
Tell Sketch, come on. I'm gonna go to the bathroom real quick.
Yeah, crying, Jimmy.
Come on,
it happens, man.
I gotta go to the bathroom.
Out here crying.
I'm in game shape. We're going to the bathroom?
Ooh, delicious. Well, you should try Prime. It's good, honey.
I'm so sorry, but I did it very bad. I don't know why. It's probably all that water I was drinking.
There he is.
But I gotta take a quick piss. I'm so sorry, bro.
My coach.
You ready, bro?
I feel good.
You look nervous, bro.
I'm not nervous.
He looks nervous.
It's called game day nerves. I'm used to the spotlight.
And you believe lies. Is that what it is? So Joe
Look at
Biden,
this.
Barack Obama, George Bush, even
Be my
Pence
brother.
are guilty of the same. Yeah, they are.
I'm black though.
Hero time traveler. They're 100%
Brother from another
all
mother.
guilty.
Love it. Brother
Joe
from
Milton is from Florida.
Let's go!
It's gonna be easy.
Let's go!
I get 1 out of 3 40-yard dashes, I'm money.
Let's go! Hold up, Chuck. I gotta take a quick piss real quick. I'll be right back. You can stay right here. What? You gotta pee or no?
I kind of do.
All right, man. Just go.
Yes, sir.
So weird, guys. I'm gonna have to skip this part.
You said what, Slips?
Which is why Trump will get immunity.
You talking to me
and
here?
They will say the Supreme
Start
Court
off with a sword fight?
that has.
Come on, you down? I sword fight
don't
right
think
now on
anybody's
God.
above
Look at
the
this.
law.
I got
don't
a
think anybody's
dagger
above
on
the
me.
law.
Hey,
You
I'm
guys
soft
think anybody's
right
above
now.
the law?
My shit's like 2 inches soft.
Hey,
Cause it's
I'm hard
cold.
24/7.
Thank you so much,
Yeah, I'm
Nathan.
like
I
so
appreciate
cold
you
right
all.
now.
Live
My,
hard, die hard.
my dick is like all loose
TikTok
and
videos
soft,
of the check in the birthday.
like a little
They
willy.
just don't
Like
get any
mucus?
views.
Yeah. Do yours get like shrink when it's cold too?
Oh, yeah.
Exactly.
But my
Nobody's
balls are
above
so
the law.
small.
Facts.
I call it turtle shell.
Yeah. Let me just
Sword
go in here and
fight.
just sniff here.
Whoa! You're already putting the pressure on me.
All right,
Sure I can
boys.
jump.
Get rid of political.
Let's get
party
right.
facts.
That was a fake
Oh
pee.
shit.
That was a
I'm
fake.
actually-
Let's get right. No, I'm just waiting for him to take a piss. I'm be honest. Ooh, I feel so much better now. I feel like, bro, I promise you, bro, taking a piss is like so relief.
No.
All right, come on, come
I
on,
knew
come on.
you were gonna do some bullshit there.
All right, let's go.
There you go.
Did you wash your hands?
We're on speed time now.
You wash your hands?
I washed my hands.
Okay, that's good.
I know I didn't hear water running when you walked out, brother.
Hell no, I don't. Yeah,
It's okay.
I didn't watch them motherfuckers.
It's all right.
Ain't that right?
It's a bumpy ride down there, huh?
Yep.
Exactly.
Couple warts?
Nobody's above the
Fuck
law.
that shit. Love you. Hey, seriously, love you too, man.
Look at him.
I'm black though. Yo,
Very
Armin,
low.
appreciate that big 100. I don't know what kind of your currency that is, but appreciate that 100, my boy. And appreciate that membership to my boy, Alden Barber. All right,
What are you playing?
let's start with the
watching
40-yard
Nitro
dash, bro. Let's stop the bullshit, bro.
You go. Who's going first?
No
Me or
one's
you?
You want me to go
Follow
first?
facts.
How do you feel?
Yo, chat, should I run
government
full speed my
position,
first
stay the
one?
same, facts.
I feel like I shouldn't, bro. I
As
feel like
median income, yep.
I feel like I don't want to run full speed my first one, bro.
We're speed. This was
Saving.
yesterday at the
Sandbagging.
NFL Combine.
Sandbagging.
Double the ante. Double the ante. You know what sandbagging is?
Gets injured.
What the fuck?
You appear worse at
Why
the
the hell
start.
are you talking like this? Like, God damn, like, I'm thinking you keep talking like this.
Okay.
Brother, and they're
And,
right, brother.
Oh, I love that shit talk.
Yeah,
Senators
I'm
and,
like, yeah, I
House
love it
Representatives.
too, bro. Let's fucking go.
Yeah.
God.
Let's see how much he yaps at the bench press.
All right, let's see.
Here, this guy eats nothing but soup and noodles.
So hell nah.
Sorry
I eat
about
chicken
that.
and watermelon, buddy.
Whoa!
All right, let's get it popping, man. Let's get things started.
You didn't tell me I could wear shorts.
What do you mean?
Whoa! He's got cleats or something too?
No, hell no. All right.
Good for you.
So you want me to go first?
Yeah.
Hold on, wait. Chat, who y'all want to go first? Mirror sketch. I look you want. Hold on, wait. I look you want who to go first. Hold on, wait. Where's my phone at?
All right, Sketch, you're gonna wait for my whistle.
Hold on,
Okay.
wait.
Put my hand up and they're gonna time you.
A lot of people are above the law.
Wait,
except
so
for
I'm
us.
confused.
Facts.
Start right now?
Full speed
You're
or
a time
no?
traveler.
You know, do you guys just
Facts.
want to run against each other? Or do you want to do 1v1 and then
No
do
one
it?
is above the law.
I feel like
Yeah.
we should.
Congrats on 2 million. Thank you so much. Appreciate y'all. Thank you.
Let's just do.
One race?
What do you want to go first?
Okay, it's rare.
Yeah.
Okay,
All right.
nice.
They want you to go first.
Okay. I like that.
Let's see how you run, buddy.
Give me the middle lane. Right here.
Yeah, that's fine. That's all.
Let's. What the fuck?
On my whistle.
Blood thinks that you say what the.
Push, push, push,
What the
push,
fuck
push,
is
push,
that?
push.
What the hell is that? 5.36?
5.3.
5.36?
It was 4 last time I checked.
5.2?
no way.
Slow as shit.
That was their first jog.
God damn, bro.
First
You are
jog.
so slow, bro. He is. All right. Full speed?
That was. It
Okay.
wasn't bad. It wasn't
There's
bad.
no way that was 5.3.
Oh, I'm tripping. Yeah, you don't got to hold my phone. I'll fight about that.
Well, watch.
That was good.
5.36, that's you?
It takes me. I'm quicker than a second per
That's fine.
10.
You're gonna run again. It's fine. On my whistle.
Wait, shoes on or shoes off? Shoes on.
On my whistle.
Go speed. Go speed.
There you go. Oh, free gas there. Free gas. 5.36. Tie.
No, what do you get? You got 5.36.
Oh, shit. Oh, shit.
5.36. Thanks for the free gas.
Wait, I can't find my... Wait, I can't find the mic. Oh, it's my time.
5.36, brother.
What?
5.36?
What? Oh, what?
That counts.
Oh, it's my time.
That counts. That's illegal. That's a legal run there.
Wait, I can't find a mic.
Ah, that's true.
Probably over here.
Oh, is this?
No, you're right. You're right. I can't run like that.
This is right here.
Yeah, where's the back piece?
Right.
Because you're behind the microphone.
Oh, it's my time.
What am I eating? I'm drinking this.
Bro, did he not time it?
I just speak it's a
Close but no
4-4.
cigar.
It's incredible.
Oh, shit.
January 19th fact.
Oh, that's not bad for your first run.
Bro, what was my time?
You'll be at 4 next time.
What was my time? Good job.
He's hating
What?
facts. Hey,
2-3.
I got no problem. People.
Oh, shit.
There you go. There you go. Fake stats.
2-3.
Oh, 2-3.
A 2-3 40-yard dash. God damn it.
You lost by 2 seconds. That's what it's saying.
Oh, no, my thing broke.
What broke?
Hey.
That's a free run there.
What do you mean?
That's a free run there.
Guys.
Bro, you on a 5.36, bro. What?
Everybody's got
You ain't run no
freedom
2.3.
Hayden just brings
What was
me
my
to
time?
4.36. Yeah.
They didn't start it? Oh, my.
There you
in charge
go.
with that?
Exert yourself.
Who's in charge with that? Hey, come on, bro. Start it next time.
Good job.
So I got to go again?
Yeah, you do. You go first now.
He blew the whistle. Oh, wait, bro. Let me go again.
You want to go again?
Yeah, fuck. Damn. I got to.
You can barely
I
hear
won't
me.
even run at full speed either.
Okay, I'll tell you. Glaze News Network. That's me, baby. That's me.
I mean, would it get my time, though?
Yeah, we'd get both of your time.
Oh, well, all right, bet.
This is lane 1, so whoever's number 1.
All right, yeah, I bet. All right, bet. Let's race now.
All right.
Tap shoes. Can we, bro? Like, can I get my breath?
Slide.
I just ran 5 miles.
I can hear you fine.
I'm ready.
Oh, thank you.
I'm in game shape.
Hey, no, not yet. Not yet.
Everything's on speed's time, I guess.
Just give me a second.
It's all right. You're looking a little nervous. Might kick these shoes off here in a second.
Oh, where's my phone at? Let me see my phone real quick. Hey, really didn't get my damn time, bro. Shoes off? Shoes off or shoes on?
Network fact.
No. No shoes? All right, bet. Hey,
that's not a bad idea.
I'm about to really dust you now. I'm about to really dust you. Bro, them dirty-ass grandma shoes, bro. I don't care about that.
All-purpose trainers.
I'm about to really dust you now.
And socks.
I got
Don't get your shoes on.
No socks.
Oh.
No.
That.
Hey, you can't. You're giving it. That's a pointer. Come on.
What do you mean that's a pointer?
There you go. Take off your shirt while you're at it, too.
All right, wait till I whistle, all right?
Wait. Bro, hey, y'all better time this, bro. Please. Yo, he cheating.
Come on,
hands behind the white mark.
There you go.
Hands behind the white mark.
There you go.
All right.
No.
Whoa, redo.
It's a race.
Redo.
Oh, yeah.
Get your shoes
Redo.
on.
He's slow out the block.
Now redo.
Slow out the block. Yes, stay barefoot.
Nah, I might put my shoes on,
Stay
bro.
barefoot.
Oh, happy birthday, Invincible. Sorry about that. I'm just seeing it, man.
Yeah, fuck that.
Happy birthday.
I put my shoes on too.
Oh, you're 1 year
Nope,
younger than,
I'm putting my
I-
shoes back on. Fuck this shit. No, sir. Hell no.
Easy money.
Easy money.
Chat, bro.
You're slow out the block.
January 13th? Okay.
You didn't even make it out to the first 10.
Them shoes are killing me, bro.
It's okay. I guess bad starts don't count.
Bad starts don't count.
2 for 2. 2 for 2. That's a legal win.
What?
That's legal.
Come on. I'm about to dust you.
Oh, here it is. Oh my God. He slammed. 4.4.
4.4.
No, ready, set, go. Come on. 4.4, my.
4.4.
Yeah, he destroyed
No way.
Jinx.
Over a second.
4.4. I can go faster.
Here you go, third try. That was good.
5.88.
I can even go faster.
4.4 is not real.
How much you got?
4.4 is not real.
6 seconds.
He would have.
Yeah, he gets.
It took him 6 seconds.
They'd be on the podium right now.
Man, shut your slow ass up.
Not slow. I'm girthy. Strength. Strength over speed.
Hey, happy birthday.
I show
Gavin
strength.
Morgan.
That's what they call me.
Take them bologna meats off, bro.
There you go. Take off your melted Crocs there.
Melted Crocs? Buddy.
That's cool.
He's definitely
I'm sure they love that in the middle
facts.
schools.
Dude, that's
I hear you're
difficult.
popular there. Me too. Not fucking. It's okay. Hostile.
Okay.
No. No. Whoa. Oh, I love it. I love it.
Oh, that's 4.44. I can go faster than that,
1 and
bro.
1.
You guys ready for the vertical jump test?
Yeah. Bro, I feel like I can go faster than 4.4. Wait, what's the fastest one?
The RKO was devastating.
4.2?
No, he's not that close to a 4.2.
Yes, I am.
0.2 seconds? That's not right. And neither is that 5.86 up there.
Yeah, that's right. 5.8. Bro, I feel like I'm faster than that. I can run a 4.1.
Feelings.
Bro, I can run a 4.1.
Facts over feelings.
Chat, should I go for the 4.1? I feel like I can get that.
Is that how high we gotta jump?
I can
Where
go
does it
faster.
start at?
I wasn't even running full speed.
How high is this?
I wasn't running full speed. I really wasn't running full speed. I can get a 4.1.
4.44 is insane.
Holy shit.
This
If
one's
he
gonna be
runs
hard.
a 4.1, that
Gravity's
would be-
my worst
I
enemy.
did us go on a 4.1.
Gravity's my worst enemy.
I swear to God I can, bro.
Do it then.
Hold it, just keep it on lock.
4.44 is insane too.
All right, what's next?
I would be
Vertical
right
jump.
there with Sketch with the 5 point whatever.
All right. Who wanna go first? I'll go first this
You
time.
first, Tyler.
Gotta make your arm first. Go to this line, so whatever that is.
Look at the beer belly. Not bad.
Beer belly? Beer belly?
Here you go. Suck in.
I'm not sucking in, it's regular.
You get 2 jumps.
2 jumps.
I don't drink beer, but I got a belly.
What do you mean?
You can bend your knees and jump. You can't just do it running.
I can bend my knees?
Yeah.
Okay.
Oh my God!
God damn!
Scratch.
Ah, it's in my arm.
It's okay.
Ah.
Whoa. He
Damn!
didn't, no, he didn't not get all those.
Yeah, yes I did.
No.
Yes
Bring
I
it
did.
down to the second rep there.
Hey, open up your eyes.
There you go.
Better stop squinting, because I for sure got all
You
of it,
better
bro.
touch that. You better touch that.
I can get the last one for sure.
He's got not a lot of gas in that tank there.
I can get it. What?
That's what I thought. That's what I thought.
I got one more.
You want to do one more?
Yeah.
You're so close, yet so
Whoa,
far
you
away.
won't even get half of mine, bro.
You know, 2 inches is a
His
lot.
vertical's insane.
Damn, how can I get that?
I so speed needs to pay
Wait, is
back
this like
on the
world
RKO.
record?
He got it though. He got it on stream.
Is this world record?
He got it on WWE.
Bro, I got like all of them almost.
Set the metrics.
24.
All right, last one, come on.
Get it. How you guys doing?
He got it. Let's go! Let's go!
That's good.
He got it.
That's good. Be next now.
Sue!
Love it. Love it.
Come on, boy!
Not bad. Not bad. This
Come
is football.
on!
Football. American football, brother. Come on.
World record!
I like that.
World
I like
record!
Was it a world record?
Watch this, though. Watch this.
All the way up. All the way up.
I'm gonna shit it on myself. Wait, why are you putting it lower for his?
What's up?
Why are you putting it lower for his?
I'm shorter.
Shorter than you.
Oh.
There you go.
It was on WWE 2K23.
Watch
He
this.
hit the RKO on.
I just got to jump flat-footed.
Yep.
I can't step into it.
That was awesome, Jack.
Flat-footed.
Whoa! Bro, there's a moved up there.
Hell
Come on.
no. Nope.
You did
nope.
not give him the same.
Nope. Nope.
There you go.
See, people want
I
to
love
talk.
it. Home field cooking.
People want to talk.
Home field cooking here. Fake ref here.
Got the world record on
ref.
that.
What's up, guys? How
Come
y'all
on, Mr. Stroot. Come on, buddy.
doing?
You got the grim. Yes, sir. Yes, sir. Fuck you mean, yes, sir?
What do you mean?
Bro, watch this. Watch this. Watch this. Watch this.
I'm dense.
Like, come on now,
I
bro.
show speeds as an
You took a
athlete.
step
Okay?
No, I did not. I took. Come on, bro. Stop talking.
There you go. Hard over height.
Harder right.
Locker room guy.
How the fuck am I a locker room guy?
Oh,
Yeah.
Let's go to bench press.
All right, let's go. Where's bench press at?
I think
bench press
Speed's-
later?
Speed beats him on bench press too.
Reaction?
You know
that's
what's your
why I
favorite
win.
Pokemon?
Let's go.
Bulbasaur.
All right, chat, so far I'm busting his ass.
I've
He
got
didn't
a
win
bulbous
once
swole
yet.
over there.
He was
I won
talking
the
all
first
that
one.
shit.
No, you can't
He
mess
was
about
talking
the
all that
boss.
shit.
I've got a bulbous swole
You're
up
locker
there.
room guy, brother.
I set the tone.
I can do this anytime of the day.
Let's see
Let me
it.
switch you
I
around.
can, but he's getting a fucking bus.
No.
You know what I'm saying,
What
bro?
camera?
That's what I told him. Stop.
So up
Talk
there
shit.
How's it going?
That's what happens when you talk shit,
is
bro.
my bulbous swole.
That's what happens when you talk shit,
I
bro.
know,
It's a
I'm just-
Bulbasaur
I'm
that's like
spreading
really
good news, bro.
muscular.
All right, brother.
Good news. I'm better than you.
So
All right,
that's
bro.
what it is.
You just haven't found it out yet.
I haven't.
And it's right next to a Gundam.
It's a learning process.
Why would the line?
You know, I
That
beat
makes
you
no
on the
sense.
first one out the jump.
What?
That's on paper.
All right,
That's
how
a
many
real
times do I
stat.
gotta
One in
verify
Bro,
this?
the
140.
stream is the proof. Go back in the stream.
Look at that.
I gotta
The
keep
fuck?
Home
verifying
field
this.
cooking.
This is stupid.
The hell? Keep saying talking. Hey, can you do this though? Watch this. Watch what I'm about to do. Can you do this? You see how everybody's going to the right?
Oh yeah.
To go over the fence. Can you do this sketch?
Thank you for the follows, guys. Appreciate y'all. You might beat speed in chess.
Is that ass okay?
That counts. That counts. That was pretty clean.
That don't count.
Hard over.
He got fucked by the fence.
No, no. It doesn't count when you graze it.
Huh?
Pole's still there. Counts.
Okay. Introduce. Oh, introduce me.
On the mic.
Right here. Hold on. We'll tell you. Sketch and.
Sketch.
No, sketch.
Oh, sketch and speed.
Yeah, speed. Sketch.
I thought he called me sketch. I thought it was like.
Kind
of look alike.
We're gonna introduce you, okay?
Yes,
Okay.
sir.
Oh, here we go. Here we go.
Game time. Game time. Ray Lewis. Cristiano Ronaldo.
No.
Megatron. Kylian Mbappe.
Welcome to my abode. In between the white lines, we're not friends, brother.
Okay, fuck you then.
It's okay. It's okay.
I'm ready.
Ladies and gentlemen, from the world of TikTok, please welcome Sketch and Speed.
Oh God!
Come on.
Thank
Now
you.
what?
Look at it. There we go. Nice and
Now
loose.
what?
Nice and loose.
Oh,
It's all about
reaction?
speed here.
Shit, can we get some likes?
There we go.
My first name?
If
My
the
first
Democrats
name's
replace
Nate.
Joe Biden
Yes, sir.
and Kamala Harris,
Look this thing
Gavin
right here.
Newsom and Barack Obama.
Hold on, wait, what's your first name? S.
Gavin
Catch.
Newsom. Who's Gavin Newsom?
My first name is Nate.
I know who Barack Obama is. but
Wait,
he can't
Nate
run
Lincoln
again.
was-
His first initial.
Oh, Higgers.
I would say that I still don't trust him.
Standard here?
Nate Higgers. Let's go. So what is this?
I wish
It's
they
speed
replaced
reaction right
Trump.
now.
Oh, just
Whoever
reaction.
hits the most
Replace
buttons.
Biden,
Okay, let's go then.
Let's do it.
California guy.
I used to box when I was younger too.
He could
Oh,
be
yeah?
vice
I
president.
I used to train Ryan
Yeah, I don't
Garcia
trust
with
him.
him.
I somehow don't believe it.
Huh?
I somehow don't believe it. Bam.
Oh,
Okay.
exactly. Okay.
Is there a countdown here?
4.
Let's go, boys.
This is all Sketch does. He should beat ISOP.
Look at this thing. This is more than I thought.
Dude, he's gonna be winded from this. Up top.
293. Oh yeah! Oh yeah! How many? 100 points? 100 points here?
Oh dang!
It's okay.
You beat
No way, I just lost to him, bruh.
Not January
I can't even
13th.
see him. Damn, I just lost.
Smoked him. Yeah, it was
I
bad.
believe it.
Wow.
I believe it. Slow reactions.
Wow.
Slow at the
Guys.
block too.
Nah, bro. Mine wasn't working though.
Complication.
Someone's turning it white and green.
Hey guys, I do apologize. I've been streaming for 3.5 hours. I'm gonna go eat. I'm gonna go work out. I will be streaming Fortnite live tonight. But I'm gonna jump off though right now, guys. I'll be streaming again tomorrow. I guess some politics, whatever, because you guys like politics. So we'll be talking about politics tomorrow morning, I guess. Every morning we'll be talking about politics. At night, Fortnite. But I love you guys. Thank you for streaming. No, this is fun. I don't mind streaming all day long. I don't. I love you guys, and I love even the haters that are in here. or the people that bow down and worship Trump, or the people that bow down and worship Biden. You guys can hang out and argue all you want to, because we have freedom of speech in my in my comment section. As long as you're not threatening each other, go for it. I don't want threats. So, and I think we need that kind of discourse. Otherwise, we're just not going to have any discourse because nobody's talking. So I'm going to be done for right now. I've been on for 3.5 hours. Not a big deal. I'll be back later on today. Love y'all. Peace. I got to go eat. And drink Prime. Drink Prime. Click out of this. I'm going to end my my